Good evening, everybody. I'm sorry we're running a little bit late, but on behalf of the Board of Education, let me say good evening. We hope and pray that you had a chance, if not earlier today, maybe a little bit later this evening, to enjoy the wonderful weather that we've been having. We are going to spend some time here this evening, if you happen to join us, on doing what we call professional development. Our goals, our strategic plan, all require that we sort of, like most professions, stay on top of our game, stay on top of the laws, the regulations that relate to being a board member. And trust me, there are a lot of them. And so we sometimes retain people outside our organization and sometimes inside our organization to give us the professional development, that is the training that bringing us up to date on various rules and regulations and laws. So we're going to do that tonight. And before we get to that, though, there's a couple of preliminary things I have to take care of. The first thing is our clerk, Kalia Wade, is not in today for very legitimate reasons. She's on a well-deserved vacation. And so we, according to our rules and according to state law, we have to have a clerk. So I'm asking that one of my colleagues make a motion to have Francine Scott serve as our interim clerk for this evening. Is there a motion?
I'll motion.
Second. Thank you, Mr. Clark. And I heard a second from Mr. Adams. All those in favor of Francine Scott serving as our interim board clerk for tonight, say aye.
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 Any objection? The other preliminary matter before we get to our professional development is whenever there is a absence from the Board of Education, there is a process. The process is dictated by our bylaws, our laws. And that process indicates that the board president must indicate the reasons behind the absence and whether he or she, the board president, determines that the absence is excused or legitimate. And I will state for the record that I received communication indirectly from, and it might have been directly. I know our clerk informed me that Commissioner LeBron would not be here tonight. My understanding is she has another professional commitment that had her tied up tonight and made it difficult for her to attend this meeting. I have made, the bylaws require that the board president make an assessment as to the legitimacy of that excuse. Without having additional detail, but understanding that Commissioner LeBron has significant community engagements and involvements, I'm going to determine that excuse is legitimate. Although I would caution my colleagues that, and I know it's difficult because we all have very demanding schedules, to particularly where you have events like this that are scheduled far enough in advance, please make sure that if you're not able to make it, that you articulate that when the Survey Monkey or whatever it is going around, so that we don't have these kind of conflicts. Again, appreciating the fact that Commissioner LeBron might have missed this on her calendar. I'm going to deem this excuse as legitimate, but again, it is very important that we all recall our own bylaws, which states very specifically, board members must attend all meetings. I did not create that rule. We as a group did, and so those are the rules that we're going to comply with. I want to get out ahead of this. Just to be clear, I'm trying to be, as board president, as flexible as possible in my assessment of the situation, but the bylaws say the board votes. And I just want to get out ahead of this. I'm just be very real with you all. I don't want somebody to come and say to me, well, wait a second, you made this excuse for Commissioner blah, blah, blah. That's not what this is going to turn into. You know why it's not going to turn into this? Because I just make a recommendation and our bylaws say the board votes. So I've determined that the excuse, based on the information that I have, is legitimate, based on what I know of Commissioner LeBron, her professional commitments, is legitimate. But notwithstanding that fact, our bylaws say the board must vote on my determination. Is there any objection to my determination the excuse is legitimate? Please indicate so on your video camera. I don't see anybody indicating that the excuse is not legitimate. So, Madam Clerk, we will record that as an excused absence, and that will allow us to go on with our professional development. As I said, sometimes we have people outside do the professional developments, the training. Sometimes there are folks inside. This time we're very fortunate to have our interim acting General Counsel, Steve Carlin. Guy's got a lot of experience in the practice of law, particularly educational law. And he's going to tell us about students and the Sunshine Law, the information that should be made available to the public. And Steve can explain that obviously much better than I can. Steve, as we say, the gavel is yours.
Thank you. Good evening, everybody. So we're going to start right up with a presentation on students in the law, which is a topic that I was just told to work on, which is an incredibly broad topic. I'll do my best to make it as relevant and succinct as possible. I can take questions as they go, but I will not be able to see your hands. So if something is really pressing, please feel free to just speak, and I'll pause. Or you can wait to the end and ask me questions. It's not a particularly long presentation. I've tried to make them both. The Students in Law one only has 12 slides of content, and the Sunshine Law one I think I have down to 7. So, but either way, and should you want to talk in any kind of detail later as far as legal advice, please feel free to reach out to me independently, as you're certainly allowed to do as the district's lawyer. Okay, so I'm going to start this up right now. Everybody's seeing what I see, which is it says Students in the Law, title page. We'll get right into it. The overview is freedom of speech and expression, then our code of conduct, and then student due process, and finally student harassment under the Dignity for All Students Act in New York law. When looking into this, really the first thing we think about is students' rights under the law. Probably the most developed as far as a body of legal cases and thoughts and everything else is students' rights to freedom of speech and expression. And it really goes all the way back to 1969, a case called Tinkerbee, Des Moines, which is taught in, I think, in a lot of classes. It involved the wearing of an armband in protest of the Vietnam War. Seems like a relatively insignificant protest, but at the time, in Des Moines, Iowa, it was considered to be a highly controversial issue. The school, the teachers were all in favor of the Vietnam War, and this student and her brother, their family was not. She wore an armband. She was told to take it off, and then she was suspended for wearing it. So, famous case for the quote that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Everybody knows that quote, or a lot of people do. It's the schoolhouse gate part in particular is kind of a, where we start as far as students are not without rights just because they're within our walls here. However, what you'll learn as we go forward is that is a broad statement that has been significantly curtailed as we've gone through various levels of cases and interpretations and new issues that arose. It's also one that's very fluid depending on where you happen to be, which circuit you sit in, which set of federal courts oversees your rights, and also the community that you live in. The community standard is one that they look at for some of the stuff. So, because in that same case, they also caution that students' rights have to be viewed in light of the special characteristics of the school environment, which is certainly something that is different than an adult operating outside of school and who possesses a much broader array of rights. Students are generally allowed to express views that are contrary to their school or their state's views on a subject. That was the whole point in the protest case. However, there are significant limitations as we'll go through. So the students really only have the freedom to express political or religious views. It's not views on anything that triggers this First Amendment protection. However, political can be a very broad spectrum of things. It doesn't necessarily mean politics in the way of an election. It's anything that's kind of at the heat of the moment in a societal debate can be considered political. But this protection includes students' speeches, their clothing, accessories they wear, armbands, bracelets, pins, handouts that they bring in, maybe from the outside or they generate internally, or signs that they hang. And a lot of the cases that have developed around this come from things like that. The freedom of expression also includes the right to refrain from conduct. It means there's a very famous case that said you do not have to recite the Pledge of Allegiance. There were schools that were actually expelling kids for refusing, especially in the McCarthy times. They thought it was a clear sign you were a communist, and they were expelling kids from school. And there were groups that said, I don't want to say it. And the courts have very, very consistently upheld the right to refrain from that. They've also allowed the raising of a fist during the national anthem in protest, and peaceful protesting, such as kneeling during either a patriotic display or the national anthem, has been upheld as well. There are some pretty strict guidelines we can follow. If speech or expression is vulgar, lewd, or indecent, or promotes illegal drug use, it is almost guaranteed to be allowed to be restricted by a court. There was a case called Bong Hits for Jesus, which a kid was kind of joking around, but he put it on a big sign, and the principal ripped the sign down, suspended him for a few days, and the courts held that promoting drug use can never be within the best interest of an educational environment. So that's where that comes from. Schools can also limit speech that causes disruption, actual cause of disruption. If you have one set of kids coming in wearing something, another set comes in with a counter protest, and that you're seeing a disruption, you can just say, everybody goes home and takes those off, and we'll start fresh. The tricky part is that they can also limit it if it has the reasonable potential to cause a material and substantial disruption. That's the kind of legal language that gets us in all sorts of litigation and trouble. And so it's also what people rely on when they want to be overly aggressive in their restrictions of things. They say, well, I thought it reasonably was going to cause a substantial disruption. What we find in a lot of cases we look at is that means that the person didn't like the viewpoint, so they were actually attacking the viewpoint. But you have to have, it can't be a baseless fear. It can't be to avoid controversy or talking about an uncomfortable subject. And it can't be because some kids might feel uncomfortable by having that thing around, because we have, decades of protest and progress that is based on somebody feeling uncomfortable about a conversation at some point. And you can also limit speech if it constitutes actual harassment against another student. Now, I feel harassed because I don't like what that shirt says this is true harassment, calling somebody names and things like that, or directly attacking somebody on a media platform. Those are all things that you can regulate. So schools' abilities to regulate speech, though, is really viewed in light of the circumstances at the school, and this can include a community-specific standard. So if there's noted gang activity, the restriction on colors or certain symbols that are associated with gangs. But if it's in the middle of, say, Iowa, and they're saying you can't wear things that we think look like, you can't wear a red do-rag because that's a blood color, and there's no blood gang within 600 miles of Des Moines, Iowa, that might be targeting, say, a minority rather than a actual gang problem. So, the courts will look at that. Noted racial or religious tensions can lead to an allowance of a more restrictive dress code for certain things, and other community-specific standards. It can be kind of anything. But we'll get to that in a moment as some specific examples. I do want to note that social media, which is a frequent question that I get asked, students' activities online or even outside of school can be regulated in the exact same manner as if they were in school. Threats, particularly these type of things, threats of violence against a student, a staff member, or the school itself. Negative images, false rumors, or calling staff vulgar names are some pretty famous cases out there where students were online and they made very unflattering cartoon caricatures of administrators, used some vulgar language to describe them. Those were properly restricted, even though the student did it on their own time, on their own webpage, and posted it without linking it to the school. Any kind of harassment that would constitute like a DASA violation, or any kind of criminal conduct. Cyber hacking is one of those things. And the same balancing test we use for speech and expression applies to these outside type things. And this can include even when school is not in session. So there's been some instances where there was summer school, or there wasn't in summer school, it was during the summer, and students were making threats against a teacher, and they were allowed to be disciplined for that. Those are kind of the questions. And our code of conduct is incredibly clear on this. Our code of conduct specifically states these things, that your time either on school grounds, at a school event, or outside of school or online can all be subject to discipline if part of this, any of these tests are met. Student dress codes, a very popular court issue, restrictions of particular t-shirts, restrictions on things that people are wearing as far as bands and buttons. Schools cannot generally control student dress based on fashion or taste. That's just, that's where you get into people's notions of morality, or I don't think that that's particularly, tasteful for a young woman to wear, that kind of thing. There are exceptions for demonstrated safety issues. Loose clothing in a lab or particular footwear for PE or for labs, saying you can't wear flip-flops for PE because you might trip and break your ankle, is different than just saying you can't wear flip-flops at all. Schools,
hey, Steve,
yeah.
with regard to the last point that you were making, is this related solely to something related to some issues that they had with regard to school, or is this any other kind of behavior that may not have occurred on school grounds?
It goes pretty broad. If it's, if one student is threatening another student and it happens off school premises or online, it is disciplinable, because that directly affects the learning environment when they come together again. That's been the court's views on that. So there's plenty of cases upholding that. Also, it has to have some kind of effect, or they're using school property. The cyber hacking case actually occurred when the student was using his district issue laptop to cyber hack, and they said since it was district property that they could discipline for using it in a manner that's not properly in an educational purpose. But any contact between students outside of school is still subject to discipline, because it will ultimately come back and affect the learning environment, is what the court's general view on that is.
So what if it's not another student in the district? Does the district have any rights there if it's not related to school, but if it's a student?
You get into a little bit more, if say it's a non-criminal manner, and it's not, so if it's a a DASA level harassment, somebody's calling somebody names or making fun of them, you're probably not going to be on great grounds unless they're using, say, a district issued device to do it. But if they're using their own phone and they're doing it on Instagram, it's going to be a little bit tighter of a call, because what's the relation to the educational environment that the school has the right to enforce? The schools are not parents to the kids, they're not police agencies, so that's where you're going to get into a much tighter idea. And I certainly would
Or if the police were involved, say there was a shooting with some of our students, does the code of conduct apply there, or does the criminal justice system apply?
Well, they both could apply, honestly. I mean, if I suppose if one of our students was involved in a shooting and they, are you talking about with other students, or just one of them's involved in a shooting?
With other, it doesn't have to be another student of the district. It doesn't have to be.
More likely than not. I mean, if we can show that the student is some type of that their relationship, that their involvement in that shooting could pose a threat to the safety of the students at the school, we could stop them from coming into the school. But if it's known that they were involved in the shooting, the police are likely going to come and get them anyway. And we just don't deal with that issue that often, because we have arrests at the school when they find out where they are. But yeah, I think that's my answer at the moment.
Yeah, the reason I asked that is because I can't remember the exact situation, but there seemed to have been an issue where there was an altercation or something that had happened off of district grounds, but there was still some kind of punitive response from the district, even though it had happened off grounds. So that's why I was asking those questions.
Sure. Well, if it ended up being gang related, you could say that there's a threat for retaliation within the school. You might want to try and control that. I don't know the specifics, but generally there has to be some kind of relation we can draw back to the school district for them to have the right to work with it.
All right. Thank you.
Yep. School districts, you can't have a blanket ban on clothing containing messages in general. Those have been upheld by some courts. And you can still restrict a particular message if it meets the restrictive test for speech and expression. For example, A Confederate flag T-shirt has been example of several court cases. Those are generally seen as something that a school has the right to ban. I would certainly argue within our district, it would be, given our community standards, it would be a perfectly legit ground to ban somebody wearing a Confederate shirt, because it would, be something that would potentially cause a lot of upset and potentially even some retaliation or violence. Examples of shirts that have been specifically protected in court cases: thoughts about political candidates or elected officials, abortion and anti-abortion rights, and also gay rights. Oh, I see. Commissioner Adams, you have your hand raised?
Yeah, I'm just concerned when I see something that says the exact opposite. It says, I can have a blanket ban on all clothing containing messages. Then later on, it says there are shirts that are protected in the court cases. I mean, that's the complete opposite.
No, it's because the schools tried to restrict only one message, not all. They didn't put a blanket ban on clothing. So in other words, if you say to all students, you cannot wear any clothing that contains any messaging, that's content neutral, and that's been approved by courts, because it's not targeting a particular expression. It's just saying we don't want any messages on shirts at all. Conversely, there's been a lot of cases where the schools have tried to pick and choose which messages they don't like because it's a controversial topic or it's something that somebody is uncomfortable with. That's when the courts will intervene and say you can't target that particular expression or speech just because you don't like the contents of it. It's a different. They weren't trying to ban everything. They were trying to ban one thing.
All right.
Okay. Student religious activity. This is in New York. It's actually a little bit more restricted than in some other parts of the country. The Second Circuit has had several cases on that. That's the federal court that oversees our federal courts. It's the higher court. So schools cannot restrict religious expression by students or prohibit religious-based student clubs, but it has to be actually student-led. In other words, it can't be at the initiation of staff members. They have to allow all religions the same rights. So if you're going to allow an after-school club, for one type of religion, you allow it for all. And it has to take place outside of instructional time. They cannot allow any type of religious instruction, even student-led, during the school hours. And that's rooted in the New York State Constitution. Student-led prayers over a public address system at graduations or other gatherings is not permitted. I think in other states that it is, in fact, as long as it's student-led, but in New York, it's not. And so in addition to some of the constitutional prohibitions, what they're really looking at is that young students are often too susceptible to peer pressure, or fear to refrain from participating in something they don't believe in, because they're afraid that other kids, are going to be mean to them or bully them or harass them. So the New York has leaned on the just keep it out, do that stuff on your own time, don't do it in school. So that's kind of the state of the law at the moment with respect to student religious activities and expression. So codes of conduct. Codes of conduct are not technically laws, but they are required for all school districts under New York State education law. And what they do is they create the set of kind of laws in the school, the expected behaviors and consequences that if you violate them, you'll potentially be subject to discipline, and even including what discipline you might face. So it's part of the due process standard for students. They have to be first told what they're expected to do before they can be disciplined for not doing it. That's what codes of conduct do. Our code of conduct is obviously very extensive. We're within inches of the goal line of finishing a major rewrite of it. It encapsulates so much of what I just talked about before. It lays out a lot of these expectations, and they can also often regulate behaviors off campus. Again, as we indicated, ours does. So student due process rights. This is an essential function of the society, is to ensure that people aren't disciplined or criminally charged or convicted without adequate due process. So students have rights related to searches, drug testing, and discipline, but they don't have necessarily the same rights as adults would have outside of school. They don't have a Miranda right to remain silent. And this is what, and I'm only talking about with respect to school administrators, not if police come into the schools. Then all the rights they had, with respect to police still remain. This is in internal administration investigations, internal searches. So the students' rights are actually set out in the code of conduct as well. So a lot of this is in there, but they do not have a right to remain silent in an educational setting with respect to administrators asking them questions.
Hey, Steve,
Yeah,
even if they're considered an adult, 18 years or over?
correct,
Okay,
correct. Because they're still our students. We have them up to 21. So
okay,
yeah, there's no distinction for age in there. There might be a distinction as far as parental involvement in some things, but not with respect to the right to remain silent.
okay, thank you.
Yep. So with respect to student searches, one of the areas of it's a type of search is drug testing. Students in New York cannot be drug tested without parental consent, period. That is in the law. That differs from other states where students can be tested. But in New York, they cannot be without express parental permission. Now, that parental permission can come in the form of, agreeing to, like a parent signs a kid consent form to participate in athletics, for example. That would still be parental permission, but you can't just randomly drug test kids or say, "I think you're high. I'm gonna send you. I want you to take a drug test." In some very limited cases, a breathalyzer was allowed to be used at a prom. It belonged to the police. The administrator who had it was trained by the police in how to use it, and it was calibrated by the police when it was returned to ensure it was accurate. But in any event, however you gather the results, if you are allowed to or not, the rule in New York is you cannot turn those results over to law enforcement. They're only to be used for internal discipline. Search of the student's property. So we're talking about book bags, coats, pockets, anything like that, by administrators, again, not police, have to be based upon reasonable suspicion of a violation of the code of conduct. And that is not the same as the probable cause test under criminal law, but it's also not, it can't be random and it can't be baseless. You can't do random bag checks, it can't be baseless. And I'm not talking about when they come in through the screening and have to have their bags examined. That's separate part. Once they're inside the school, you cannot have random or baseless searching of the student's own property. And even when you do have some reasonable suspicion, you're supposed to use the least restrictive means possible. So if you are looking for, a gun or a large metal object, a pat down may be sufficient. You don't need to make somebody empty everything out. And one thing, strip searches are completely prohibited by our code of conduct. They have to be prohibited by the code of conduct because, believe it or not, they're still legal. So our code of conduct says no, we're drawing the line, no strip search allowed. Conversely, lockers, desks, and computers and any other school-owned property can be searched anytime. It's in our code of conduct, and there's a reasonable expectation that that's not private for students because it's district-owned. So we can go in and do that. And that's an important distinction from something a student brings in on their own, such as a backpacker coat. So due process for discipline, there's a couple of points. In addition to having to be on notice, if you are found to be or thought to be in violation, you absolutely have the right to present your side of the story. That's just a basic due process right carried over from criminal law. For short-term suspensions, which are 5 days or less, or classroom removals, the administrator who wants to issue the suspension has to provide the basis for the reason they want to suspend to the parent and to the student, and they have to have a small conference where they consider the student's version of the events before issuing a final decision. Conversely, in a long-term suspension, which is over 5 days long, there has to be a full hearing within 5 days. It has to have evidence presented by the district. It has to have testimony. It has to allow the student to get up and testify. And there has to be a neutral hearing officer who decides whether the suspension being recommended by the principal is appropriate or not. Students can appeal the long-term suspension decisions to the Board of Ed. We often sit and listen to appeals. And then if they disagree with the Board of Ed, they can go all the way up to the Commissioner of Education. So, a couple points in there. It's written notice. It's an opportunity to be heard, and it does follow some of the notions that we think of as due process in the criminal world. one of the other thoughts is that discipline should be progressive, except in extreme cases, and proportionate. But there are exceptions in both, that you shouldn't be removing students without giving them the suppress, except if there's an immediate threat of harm. For example, if they came in with a knife, they came in with a gun. We're talking about different things there. So sometimes you skip some steps in the progression if there's extreme. And then corporal punishment is not permitted in New York under a specific regents regulation. It is still permitted in 22 states, unfortunately, but it's not in New York. And then finally, students have the right to have an education that's free from harassment. And that's one of the important rights that I wanted to highlight. There's two main laws that govern this area. There's the New York Human Rights Law, and there's a Dignity for All Students Act. And these allow some protections that are beyond what you get in your typical federal ideas or people who've seen this in education, such as weight and appearance, hairstyle, and then something called traits associated with race. So it's a much broader protection than you get under some of the federal civil rights statutes. And that's because there may be things that aren't just about race, sexual identity, or gender that still could really ruin a kid's learning environment. And those are all things that can be subject to complaints particularly under DASA, as we refer to them. Our code of conduct incorporates all of these. That's something that is just there. And there are DASA coordinators in each school who are responsible for ensuring that if a student is subject to this, that there's a report and an investigation, and then ultimately potentially discipline and notice to the parents as to the outcome and all that. So that is the end of the presentation as far as students in the law. I'm sure there are areas that students fit into in the law, but there's so much, I didn't want to be too crazy. I kind of tried to hit on some of the major rights-based questions that students would have, or discipline type things. So anything else you want to talk about, I'm certainly always open. And if you have any questions, let me know now before I move on to the next presentation. Very good. All right. Well, the next one is the New York Open Meetings Law, also known as the Sunshine Laws. You all are aware of this because you're sitting in an open meeting right now. Although technically we do not have to be. It's one of the exceptions that we'll talk about in a minute. So the notion of the Open Meetings Law comes under the Public Officers Law. It's also called Sunshine Laws. It's federally recognized. Most states have these. It gives the public the right to attend meetings, to listen to the debates, and to watch the decision-making process in action. It does not give the public a right to speak, although it's strongly encouraged. It does not give them a right to speak. Boards are free to set the standards as to how people are allowed to speak. They just have to be fair and reasonable. They can't be discriminatory. They can't be exclusionary. If you allow some to speak, then everybody has to be allowed to speak. In our case, the board bylaws set those standards, these parameters for when people can speak. It also requires that the public body at issue has to give adequate notice of the time and places of the meetings, and to keep minutes in case somebody wants to review them at some point. So, what is a meeting? That's the first major question, right? What's a meeting? It requires a quorum generally, but it can also be a designated committee of less than the quorum if it's been designated to take official board action. So when you all used to meet in committees of 3, those are still subject to open meetings law, because you're basically doing the work, you're delegated to do the work of the larger body in the small body. So the public has the right to watch these deliberations and listen to what's being said. And it's only a meeting if you're gathering to discuss public business, but you don't have to necessarily have an intent to take an official action either at that time or even in the near future. If you're discussing something that's of interest to the public, it is considered a meeting that has to be open. But there are several cases where that's not. So things like chance meetings of if 4 of you bumped into each other at the same social event and you're not discussing, business or deliberating, that's not an open meeting. Professional development or informational sessions where you are not deliberating, but you're only being spoken to and maybe allowed to have a Q&A like we are right now, does not have to be an open meeting. It certainly can be, but it does not have to be. Retreats, which you sometimes have where you're working on either relationship building or communication skills, are specifically exempted from this in a couple of opinions from the open meeting committee. However, if in your retreat, you're trying to form, say, board goals that are specific to educational outcomes of students or financial considerations, those are considered to be public meetings because you're deliberating about a fact that's very important to how the taxpayers' money is being spent. And then social occasions in which a quorum may be present but doesn't discuss official business. There's oftentimes where 4 of you are at the same event, as I indicated, especially in this community. As long as you're not all sitting together and having a side meeting about a particular board matter, there's no issue. And meetings can occur via video conference. However, meetings can't be held via telephone or through the use of email. Generally, there's currently an exception that allows for telephone meetings, but that will not be around forever. So the general rule is that we can use video conference, and we have that in our bylaws as an allowance as well. Discussion of official business. So what the New York Court of Appeals said that every thought, every affirmative act of a public official it's for the public to see. But there are carve-outs, discussions of legal advice between the board and its attorney, just like any other person or corporation, can be excluded from public disclosure. And then there's certain designated items that can go into what we call executive session, as you all know. And I've only put the ones that are applicable to us. The first 3 are really law enforcement exceptions, but for us, it's D through H are the important ones. Litigation, collective bargaining, things involving any of the medical, financial, credit, employment history, or matters leading to the appointment of a person or a corporation. So it's not just limited to our employees, it can be a prospective hire, somebody we're going to have a contract with. Those are all subject to executive session privilege for the same reason that the sale of real estate or litigation could be. You don't want to give competitors a competitive advantage or somebody you're trying to negotiate a contract with. You're allowed to have some bargaining power in essence. And then anything involving grading or administration exams. One thing that's not listed on here would be when you sit as an appellate body over student discipline appeals, because that's separately accepted under one of the federal laws that allows us to keep things out, particularly under FERPA. So in order to enter executive session, you have to have a motion and a majority vote. The board has to specifically state the reason, which is why sometimes I jump on screen and have to put my finger up, although we've been pretty good about that of late. And you have to you can't just simply recite one of the reasons right out of the code. You have to give some texture to it, except for that F exception. You do not need to identify the person or the company, because that in itself could be a problem as far as disclosing information. And if there's any kind of detriment to the financial or safety, financial condition or safety, then you can avoid certain details about either what you're going to talk about or the people, but generally have to put a little bit more onto it. So email is discoverable. There are distinctions between what you're allowed to do in email. This is one of the areas that a lot of boards get into trouble. It starts out as a simple FYI email to the whole board. Somebody chimes in on the topic, somebody else chimes in on the chime, somebody else chimes in. All of a sudden, we're in a deliberation. The board can't do this because it's not public and people aren't able to see it. And so if you walk into a board meeting with your mind already made up because you had 100 emails that kind of form the question, that's against the open meetings law. So you can have some exchanges. For example, if one board member is kind of providing some background or a level of expertise that they might have that nobody else does, and it's a one-way communication, that's fine, because that will be conveyed generally when you're in your deliberations. Well, we know that we know something more about this topic, we're going to talk about it, and what does everybody think? But then it can't, again, turn into the back and forth. The only exception is if it's the board's attorney, if it was with me and people were seeking some kind of advice, since that's not subject to being public anyway, we could do that via email because it's not discoverable in terms of a FOIL disclosure, nor is it subject to the open meeting law. And a decision or a directive should not be made via email, again, except if you're advising me of something that you want me to do. So under FOIL, the question of, what is a record? The FOIL is the Freedom of Information Law. It's New York's instead of the open meetings law, it's the paper-based disclosure of all things. And the definition of a record is incredibly broad. It's really literally almost any piece of information we have that exists. One of the distinctions is that we do not have to create documents in response to FOIL requests, but there's virtually nothing that we don't own within our systems that we can't, that we don't have to disclose unless it meets one of the exceptions down here. So certain records are exempt. They kind of are like the things that you don't have to talk about in public. They very much mirror that. So anything exempted by other laws, and in that we're talking about HIPAA, the health privacy, FERPA, which is the student record privacy, and then attorney-client privilege documents, or something that might constitute an unwanted invasion of personal privacy. So things from personnel records, banking information, social security numbers are protected under a certain law. Home addresses and personal phone numbers don't have to be given out. And then discussions of contract negotiations. And then this last category is the one that gets to be litigated a whole lot, what we call intra and interagency records. So that's sometimes if there's just an email back and forth between two people in which no final decision is made, those are not subject to disclosure unless it's really just sending data back and forth. And so those are where, again, there's a lot of litigation over whether something falls within that that record exception. But we deal with that on a frequent basis over here when these requests come in. So there is a lot of additional information on this particular website. There's a whole thing called the Committee on Open Government. It has a bunch of advisory opinions. I check it frequently when people come to us with questions about whether something has to be disclosed under FOIL or not. And that is the end of that presentation. So any questions on that? No? All right. Well, I'm going to stop sharing here. I can see all your smiling faces because it's 6:20 and I kept my word. So I will turn it back over to President White.
That was quick, Steve. A lot quicker than anybody thought. All right, well, there is no executive session stuff, materials that we have to go over, and there is no new business, I assume. So there's only one other thing that we have to do this evening, which is to have someone make a motion to adjourn.
Motion. I'll reluctantly make that motion.
I heard Commissioner Malloy first, and then I heard Commissioner Clark second. All those in favor of adjourning and going home or being home with your family, indicate by saying aye. Aye.
Aye.
I assume there's no nays? Guess not. All right. Well, good night, everybody. Be safe.
Good night.